My friend Brandon was a racist. He was in the KKK, um, and he loved saying all these racist things. He just loved being in the KKK, and he would tell me about it. He even supported Israel. So today we're going to be doing the First Amendment non-required cases. Last night we did the required cases that were from Juski and whatnot. Um, so we're gonna start off with Brandenburg v. Ohio. First, the key principle of it is gonna be the First Amendment, which is free speech. He was arrested for giving a dangerous speech during a KKK rally, um, and it included racist and threatening language. He was arrested under an Ohio law that banned speech that like advocating for violence and illegal stuff and whatever. And the Supreme Court ruled that the government couldn't punish speech unless it was directed at it and that speech incited immediate legal action, um, and it was likely to produce such an action. So the case was replaced. Case replaced the older clear and present danger test from Schenck, um, one of the cases that we reviewed yesterday in the United States, with the imminent lawless action test, which provides stronger protection for speech. Um, yeah, so holding speech is protected unless it's intended to cause imminent lawless action. Government cannot punish speech that is merely offensive or extreme. It replaced the clear and present danger test with the imminent lawless action test. It strengthened protections for political and controversial speech, and it set the modern standard for limits on free speech. One way we can remember this one would be like, I don't know, just come up with a story. I like coming up with stories and then I remember it way easier. So, for example, my friend Brandon was a racist. He was in the KKK, um, and he loved saying all these racist things. He just loved being in the KKK, and he would tell me about it. He even supported Israel. So you can say something like that. Um, I don't know. You could come up with a story. Doesn't matter. The next one we got is Texas v. Johnson, a case from 1984. Um, so it consists of the First Amendment, again, which is symbolic speech. It's a key principle of it. The summary was that Johnson, he burned an American flag during a political protest at the somewhere. He was arrested under a Texas law that made flag desecration illegal, and the Supreme Court ruled that the flag burning is a form of symbolic speech protected by the First Amendment. And even if it's offensive to many people, the court held that the government can't prohibit expression simply because society finds it disagreeable. So the holding of this would be that flag burning is protected, symbolic speech under the First Amendment. Government cannot ban expression just because it's offensive. It also reinforced protections for political protest. It strengthened the concept of symbolic speech rights, and it limited the government's power to regulate expressive conduct. Um, the next one we're going to do is Mapp v. Ohio, a case from 1961, with the key principle being the Fourth Amendment exclusionary rule. The summary of this were police officers searched Mapp's home in Ohio without a proper warrant. They found illegal materials in the basement, and Mapp was arrested and convicted based on the evidence. The Supreme Court ruled that the search violated her Fourth Amendment protection against unreasonable searches and seizures. The court applied that the exclusionary rule to the states, meaning that evidence obtained illegally can't be used in court. So the holding of this was that warrantless search of Mapp's home violated the Fourth Amendment. Hold up, back. It created and applied the exclusionary rule to the state courts. Also, illegally obtained evidence cannot be used in criminal trials. It also incorporated the Fourth Amendment to the states through the 14th Amendment. It strengthened protections against unlawful police searches as well. The next one is we have the one about I think he was the rapist. I'm not sure. Miranda. Um, Fifth Amendment, self-incrimination, key principle. The case summary for this one is Miranda was arrested and questioned by police without being informed of his rights to remain silent, which is now known as Miranda rights, his right to an attorney, and he confessed during the interrogation, and the confession was used to convict him. The Supreme Court ruled that suspects must be informed of their Fifth Amendment rights before police questioning. Without the warnings, statements made during interrogation cannot be used as evidence in court. The holding of this, suspects must be informed of the rights to remain silent. Suspects must be told that they have the right to an attorney, and statements made without these warnings cannot be used in court. It also established the Miranda warnings used by police today, as I said a few seconds ago. It also strengthened protections against self-incrimination during interrogations. And then we have the next one, which is Griswold v. Connecticut. So for this one, it was a case in 1965. The principle of this would be 14th Amendment, due process clause, and implied right to privacy, right? So the case summary of this would be Griswold was arrested for providing birth control information and materials to married couples with which violated a Connecticut law banning contraceptives. The Supreme Court ruled that the Constitution protects a right to privacy even though the word privacy does not appear explicitly in text. And the court found that this right is implied through several amendments in the Bill of Rights and applied to the states through the 14th Amendment's due process clause. The holding: the Constitution protects a right to privacy in personal decisions. Government cannot interfere with married couples' decisions about birth control. Connecticut's law banning contraceptives was unconstitutional. It also established the concept of an implied right to privacy, and it became the foundation for later privacy-related cases as well. Next one is Dobbs v. Jackson, the Women's Health Organization, a case in 2022. Key principle of this was 14th Amendment and due process clause. Case summary was Mississippi passed a law banning most abortions after 15 weeks of pregnancy, and an abortion provider challenged the law, arguing that it violated the precedent set by Roe v. Wade, which was a case in the 1970s, which recognized a constitutional right to abortion based on privacy. And the Supreme Court ruled that the Constitution does not guarantee a right to abortion, and it overturned Roe v. Wade. So the decision returned the authority to regulate abortion to individual states. The holding of this, the overturning of Roe v. Wade, and it ended the national constitution right to abortion. It also ruled that the Constitution does not protect a right to abortion. It returned power to regulate abortion to state governments, and states can now set their own abortion laws and restrictions, and it marked a major shift in constitutional interpretation of privacy rights. I think that it was super dumb. Why are you overturning Roe v. Wade? What's wrong with you, man? Come on, lock in. Okay. Next one is gonna be Furman v. Georgia. 8th Amendment, cruel and unusual punishment, key principle. The case summary of this would be Furman was sentenced to death in Georgia and argued that the death penalty was applied in an unfair and inconsistent way, which violated the 8th Amendment's ban on cruel and unusual punishment. The Supreme Court ruled that the way the death penalty was being used at the time was arbitrary and biased. It often depended on race, location, or the discretion of juries, and this effectively halted the death penalty nationwide until states created fair procedures. The holding of this was that the death penalty systems at the time were unconstitutional due to arbitrary application. It violated the 8th Amendment's protection against cruel and unusual punishment. It forced states to reform their death penalty laws, required clear, objective guidelines for sentencing, and it temporarily stopped executions across the United States. So I think the most important ones right there was that had to establish non-arbitrary, unbiased, objective rules for sentencing someone to death. And then we have Greg Heffley v. Georgia in the next one. So he was convicted of murder, argued that the death penalty itself was unconstitutional. Shoot, I'm like blanking. I'm shooting blanks. It was unconstitutional under the Eighth Amendment after states revised their death penalty laws following the Furman decision. The Supreme Court ruled that the death penalty is unconstitutional, even if it's applied under fair, structured, and non-arbitrary procedures. The decision allowed executions to resume, and the death penalty, for the holding, the death penalty is not inherently cruel and unusual punishment, and it's unconstitutional if states follow fair and objective sentencing procedures. It allowed executions to resume nationwide, and it established a two-phase trial system. And then the next one is going to be, boom, we have Plessy v. Ferguson, Obergefell v. Hodges, and then UC Regents versus Back. So we're getting tag teamed by cases. I'm not Mike Ross, so hopefully we could survive the threesome of cases. So number one, Plessy v. Ferguson. Key principle, 14th Amendment and the Equal Protection Clause. Case summary was Plessy challenged a Louisiana law that required racial segregation on train cars. He argued that the law violated the Equal Protection Clause of the 14th Amendment, and the Supreme Court ruled that segregation was unconstitutional as long as the separate facilities for different races were equal in quality. So the decision created the separate but equal doctrine as well, which allowed legal segregation for decades. The holding? Racial segregation is unconstitutional if facilities are separate but equal. I hope I said constitutional. It upheld state laws enforcing segregation in public places. It also weakened the Equal Protection Clause of the 14th Amendment. It also legally justified Jim Crow laws across the South, and it remained the law until it was later overturned by Brown v. Board of Education, which was a case in the 1950s. So I would think of Plessy v. Ferguson as that one evil case in this bunch. When I think evil, I think Plessy. So evil Plessy, evil Plessy, evil Plessy, evil Plessy, So there, Obergefell v. Hodges, the key principle for this one would be the 14th Amendment, which is the due process and equal protection clauses as well. Case summary, Obergefell sued the state of Ohio after it refused to recognize his same-sex marriage. He argued that the ban violated his constitutional rights, and the Supreme Court ruled that same-sex couples have a fundamental right to marry, and the state bans on same-sex marriage violated the equal protection and due process clauses of the 14th Amendment. Holding, it legalized same-sex marriage nationwide, and marriage is a fundamental right protected by the Constitution. State bans on same-sex marriage violated the 14th Amendment, ensured equal legal recognition for same-sex couples. It also expanded civil rights and marriage equality across the country. So we have Plessy, which is evil. Then we have Hodges, which is like the gay god of happiness, right? This is probably one of the more happier cases. So think of Plessy as evil and Hodges as that rainbow, if you can taste it. And then we have Back, principle, 14th Amendment, Equal Protection Clause. The summary of this, Back was a white applicant. He was denied admission to a medical school at the University of California. He argued that the school's affirmative action policy, which set aside seats for minority applicants, discriminated against him. He felt like it was unjust, and the Supreme Court ruled that racial quotas were unconstitutional, but race could still be considered as one factor among many in admissions decisions. The holding of this was that strict racial quotas violate the 14th Amendment. Race may be used as one factor in admissions decisions. It upheld the concept of affirmative action in limited form. It required admissions policies to be individualized and not quota-based. It also set the framework for future affirmative action cases. So this is big, right? Like, this was big. Now what we kind of have to do is just kind of go over them. Again, kind of not in order, but just in a basic type of way, you know. So starting off with number one, it would be Plessy v. Ferguson. Basically, segregation was allowed if facilities were separate but equal. So like I said, freaking evil case. Shank. When I hear Shank, I visualize violence. Because Shank, in like laying in like a lingo street slang and whatever, it's like stab. So Shank, violence, but anyways, speech that creates a clear and present danger isn't protected in the Shank case. In Brown v. Board of Education, school segregation is unconstitutional because it's unequal. In Matt v. Ohio, illegally obtained evidence cannot be used in court. That was when the treasure chest of freaking porn comics were in there. Angle v. Vitale, school-sponsored prayer is unconstitutional. Gideon v. Wainwright, poor defendants have the right to a free lawyer. Griswold v. Connecticut, the Constitution protects a right to privacy and personal decisions. Miranda v. Arizona, police must inform suspects of their rights before questioning. In Tinker v. Des Moines, students have free speech rights at school. Brandenburg v. Ohio, speech is protected unless it causes imminent lawless action. New York Times v. United States, the government cannot easily censor the press before publication. Wisconsin v. Yoder, religious freedom can outweigh compulsory education laws. Furman v. Georgia, unfair and arbitrary death penalty systems are unconstitutional. Roe v. Wade, the Constitution protected a woman's rights to have an abortion. Gregg v. Georgia, the death penalty is unconstitutional if applied fairly. UC Regents v. Back, where racial quotas are illegal, but race can be one factor in admissions. Texas v. Johnson, flag burning is protected by free speech. McDonald v. Chicago, the right to bear arms applies to the states. And then Albertville v. Hodges, same-sex marriage is legal nationwide. And then Dobbs v. Jackson, where the Constitution does not guarantee a right to abortion, and the states get to decide. I remember all of those, right? Ask me whatever. Ask me a question. Oh, what's the KKK one? What was his name? My friend Brandon. He was a racist. There we go. Boom. You see, look, you see Brandenburg, right? Like, come up with these things to help you memorize these cases, and after this, that's what I'm gonna do. So hopefully, we don't bomb. So yeah.